So thank you. We move on to the next point on the amended agenda. This is Mrs. Reda's report on harmonisation of certain aspects of copyright and related rights in the information society. Mrs. Reda, like your colleague, if you could stick to 10 minutes, that would be excellent.
Thank you very much. I'm very glad at the high level of interest that has been shown by many members across different committees, and I would like to thank all the shadows and the other members who have gotten involved so far for the very fruitful exchanges we've had. I think this high level of interest really highlights the importance of the copyright reform on the Commission agenda for this year, and I hope that the Parliament position will be an important input to the Commission's copyright proposal that it's going to come out with later this year. My draft report has received support from a lot of stakeholder groups, including from academia, from authors, from IT businesses, and from consumer rights groups. And I think this really broad support from very different stakeholder groups makes me confident that we are on the right track to strike a good balance between the access to knowledge and culture and completing the digital single market and the protection of authors. There's also been some criticism, particularly from collecting societies, though some of the concerns that have been raised, I think, are due to misunderstandings about the meaning of some parts of my report. I've discussed it with some colleagues who have requested more clarification about some of the points of my report, and I've therefore made a document that really gives examples, paragraph by paragraph, for all points of the report. It has been circulated to the advisors by emails just at the beginning of the meetings, but if you have not had a chance to get a copy, I have also brought some copies that I will be happy to share with you. The InfoSoc directive is indeed a very technical piece of legislation, and therefore I think it's really important that we go into the details of all the different provisions that are part of the evaluation that I've tabled. In the draft itself, I could not always go into as much detail as I would have liked to explain every finding that I raised because of the short character limit for the draft. But of course, there is a possibility to also add more explanations through amendments, and I would be happy to be able to collaborate with a lot of colleagues on this endeavor. One of the most important sources for the report are the results from the Commission's extensive consultation on copyright reform that it has made last year to prepare its proposal. And the Commission received a lot of responses, many thousands of responses also from individuals that show that with the copyright reform we're really having something where citizens are actively asking for more harmonization from the European Union. And these responses show that the harmonization that has been attempted in the InfoSoc directive has not been enough to complete the digital single market and to provide the necessary legal certainty for users, for authors, and for companies to really know what is allowed and what is not allowed when sharing works online and offering new services. Almost all of the respondents in this consultation have reported difficulty with services that are not available in their country, and the Commission has made a very clear statement in favor of solving this problem through the copyright reform. And I think this is really also important for authors who are currently losing revenue because consumers are not able to buy access to the works that they would like. So one of the main goals of the copyright reform should be completing the digital single market and ensuring that all Europeans have access to our rich cultural diversity. The debate around my draft report has also recently been complemented by a very interesting report from the United Nations High Commissioner for Human Rights, who has been looking at copyright policy and the right to science and culture. And this report finds that to ensure the protection of authorship as a fundamental right, which is a fundamental right that applies directly to authors and not to rights holders, and thereby is really in line with the continental tradition of the droit d'auteur. This report makes two important recommendations to protect the authorship as a fundamental right, and these two recommendations are also reflected in my evaluation of the InfoSoc directive. The one is that authors need to be strengthened when negotiating contracts with rights holders and to outlaw unfair contractual terms. Here we really have an area where so far the European Union has not done enough to protect authors. And the Legal Affairs Committee has last year also done a study that has been looking into these contractual terms and come up with some recommendations of what we can do to improve copyright contract law in this regard. The second recommendation from the High Commissioner for Human Rights is to have strong mandatory exceptions to copyright. This is important for authors, not just because remuneration rights that are attached to exceptions are often an important source of income for authors, but also because the authors themselves rely heavily on exceptions when they are creating new works that are based on the work of others. In these two important points, the UN fundamental rights position is completely in line with the recommendations for reforming the InfoSoc directive. I would like to include with just one example of how important these mandatory exceptions are to authors. I've discussed with a number of documentary filmmakers who have complained that when they have finished a documentary film, they very often have to consult with their legal department and recut the finished work because it is often not clear which material they can use under a copyright exception and which material they cannot use. This is particularly difficult in cross-border situations because the use of copyrighted material may be allowed in one country where a filmmaker is making a documentary, but the film using this material is not allowed to be distributed in another country that doesn't have this copyright exception. So really having an exchange of cultural works across the Union would be much easier if we could agree on the same copyright exceptions and the same interpretation of these exceptions to apply in all countries. Cross-border cultural projects such as, for example, the bilingual TV station Arte cannot make the full use of copyright exceptions such as parody at the moment because they are not identical in the two countries in which this TV station is operating. So having more mandatory exceptions that are up to date to the technological development of today will be helpful for the users, for companies that want to offer services in the digital single market, and for authors who want to work on the build of on the works of others. So I really look forward to your contributions to this very important file and hope that we will be able to give an important input to the Commission as it will come out with its proposal for copyright reform.
Merci beaucoup, Madame.
Thank you very much. There are a lot of requests for the floor. And I would also like to take the floor as shadow, if I may. If you think it's better that I just take my normal place on the speaking list, then that's fine. But Mrs. Le Grip can take the floor first of all, please.
Merci, Monsieur.
Thank you, Chairman. Mrs. Reda, I have to say that reading your report, I was left with some concerns. This is the second time you've had the opportunity to tell us about the thinking behind your work in the jury committee, but I'm left with many concerns and doubts. On the one hand, you say that you set out the principles, the acquis, etc., which I fully subscribe to, but on the other hand, or other hands, you seem to make proposals which are entirely contrary to the principles that you say you're using, and I'll explain what I mean. For example, point 3. I fully agree with your point 3. You remind us of the need to improve the situation for authors in their contracts and the need for people to have legal protection for their artistic creation and to have correct payment for everything for which they are rights holders. However, your proposals, your suggestions, I think, seem to show an ideology which runs against the protection of our creative industries and of authors and actors. I'll go through some of your proposals and make comments. For example, you set the tone in point 1. In your point 1, you say that you have to look at the perspective of the final users. You only refer to the public consultation carried out by the European Commission. So what this means is that you think that the response of actors, editors, producers, authors doesn't even deserve to be taken account of, not even referred to. Points 10 and 11. You refer to the many exceptions to copyright, and you want to make them compulsory in 2001/29. But what about flexibility that member states have today to legislate according to national or local specificities and to take account of cultural differences? As we've already said here, for me, copyright I think that if you multiply these exceptions, then you're not going to protect these rights, but you're going to undermine the rights. Then points 9 and 23, you want to have absolute equality between digital and analog, but we know that the two markets, the digital and analog markets, absolutely do not work in the same way. You want to see the end of geo-blocking. Again, that doesn't take account of the economic models of European stakeholders. On the contrary, an end to geo-blocking would favour the bigger players, and as we know, most of these are from the other side of the Atlantic and are not so present on our continent. Not all stakeholders have the same financial abilities. So, given the specificity of the supply, there may be limits in certain areas. The idea of a pan-European license, I think, would be an impediment. We have to take account of the cultural diversity on our continent, language, culture, etc. So it means that not all works will be able to have access to the same audiences. Or do you only want to focus on works that are in English? Again, I still have considerable doubts about this. Your point 13, you want to see the introduction of a fair use standard along the lines of the American system. I think that would create increased legal uncertainty. Again, the American fair use model does not seem to be particularly fitting here. I'm coming to my conclusion, Chair. Point number 20. I think this is very delicate here. The European Commission itself think that it's an extremely touchy, extremely difficult subject. I could go on, but I don't want to monopolise the speaking time too much. But I think that already gives you a good idea of the content of your draft report. We want to work with a lot of goodwill. I hope we'll be able to reflect calmly on the rights and responsibilities of everyone acting here, but not at the cost of cultural diversity or of those in the creative industries in our continent. Therefore, I think your draft report has to be amended urgently. And I'll just finish by saying that I think we do have to focus on two particular issues, which I don't think are part of your priorities. Piracy, which is a real scourge, and unfair competition on online services. And the second point, which doesn't seem to be included in your priorities, is tax disparities, which can also be an impediment to investing in several countries. So I think that should be a general overview of my points. Thank you. Mrs. Ferreira. If I could, I would ask you to limit your interventions so that we can get through all 10 or so people who want to take the floor.
Ferrara, moi? D'accord, merci. Una delle caratteristiche.
One of the features in law, when you look at progress, you have obsolescence. This is a direct derivative from progress. So the own initiative report on the revision of the directive on copyright and information society, I think we have a real attempt here to keep up to date with the times, and I would like to express appreciation for the excellent work done by Mrs. Reda, but also for her courage to discuss some typical taboos that we see when discussing copyright. We tend to be focused on budget, and to compensate for damage, not just for final users, but also by the authors themselves. I would just recall that copyright is supposed to promote creation and the spread of art and culture. In the last 25 years, we've seen the digital revolution, which has changed our lives, but also has changed our habits. And given this revolution, the response from legislators has been quite reactionary in many places, and using all legal tools available to do this. In the copyright sector, the interpreting booth is asking you to speak slightly more slowly, if you may. But please don't make your text any longer because of that. But you're speaking very, very quickly.
D'accord.
Given this revolution, as I was saying, the response has been quite reactionary. In copyright, lots of special protection has been used, and this has led to a proliferation in legal tools. There's a paradigm which justifies protection, and copyright has been brought closer to patent law, but there's also an increase in barriers for using works for on the part of users, leaving a reduction in the criteria for having this protection. So given this digital revolution, we have seen an attempt to close the door before the horse bolts. But what this has meant is that we are sure that this excess in protection has been in order to stop illegal downloads. But has forgotten about the real reason for copyright law, to promote the creation and dissemination of cultural works. So it's time to take account of the fact that the chair apologies. I'm going to ask you to slow down again. The interpreters are sweating and the booth are going to steam up quite quickly.
Io credo che dobbiamo avere il
We have to be courageous enough to take account of the fact that the world has changed. The separation between the author and the final user has decreased. We have to remember the trilateral relationship between the public and the authors or creators through the entrepreneurs in the middle. If we want to keep up to date with innovation, we have to review the system, because the whole system is changing at the moment. So the Reda document can of course be improved through, and we'll see that through the amendments. However, I would like today just say that what we're trying to do is to put an end to protectionism in copyright law. That has enriched multinationals working in the sector without actually ensuring sufficient protection and remuneration for authors. It's created problems for the citizen users and has restricted access to culture and to knowledge. Thank you.
Merci beaucoup.
Thank you, and apologies for having asked you to slow down. Mrs. Rendibol.
Yep, so, thank you, Chair. Yes, everything is changing. First of all, I'd like to thank the rapporteur for her report. But because it's changing, we need to reaffirm what copyright is about. And copyright is about protection. It's actually allowing artists and creators to earn money from their works. And that's the fundamental principle here. And that's where we must stay with this. Otherwise, we're going to completely lose the direction we're going in. What we're talking about fundamentally is fair remuneration. And that must absolutely be our starting point. And I must also add to what Mrs. Le Grip said about geo-blocking, and that if we do away with that, that would favour larger players. As an English speaker, I actually feel very strongly about this, because the market is already overloaded with American products, and the last thing I want as a British person, and I'm sure all of you, as from other member states, want is actually more American programmes in Europe. And if we do away with geo-blocking and we actually introduce something along the lines of a single European copyright, we will find that the big American players have more access to the market and we see more of them. And I think in this committee we need to be very aware of that. And we, of course, within that, need to protect our own cultural diversity, which actually means smaller language groups, those from smaller member states, being able, under the regime, to create their own programme, their own content, and to be able to enjoy things in their own culture and their own language. And I think that also is a very important principle. I had three particular things that I wanted to pick up in this report, some of which have already been mentioned. Firstly is the open norm and fair use, which is, as Mr. de Grip said, an American concept and works in the United States because there is a large body of case law. It's a common law system in the United States, and they can do it in a way that I don't think would work here because European legal systems are on the whole different. So I think we need to be very careful about that one and be aware of the pitfalls of it. The other thing I wanted to talk about was the question, the clause 19 on education, where I do think that needs tightening up. I mean, we can't talk about non-formal education because most things can be classed as non-formal education. So that's an important one as well. In terms of the other things that Mrs. Le Grip talked about, which aren't there, which is piracy and tax disparities, I think that's worth sort of thinking about, because one of the things that I found about this report as a general point is that this was meant to be an evaluation of the 2001 InfoSoc directive. We've seen a lot of new stuff in this report, some of which I think is quite dangerous, and we haven't actually seen a lot of evaluation of what went before. So I'm certainly finding a little bit in a bit of a quandary about this, about how we take it forward, because I don't feel we've had enough on what went before to base what we want to do in the future on. And I think this is particularly important when we talk about analogue and digital, because in 2001 the world was very different, and I think that's another issue which is important here. So I think we need a lot of amendments and a lot further consideration to this report so that we get something which is actually acceptable to the majority of the committee.
Merci.
Thank you. Mr. Costa.
Ich kann im Wesentlichen die Ausführungen.
I can agree in the main with Mrs. Honeyballs' comments, but I would like to pick out a couple of aspects in particular in greater detail. I'd like to thank Mrs. Reda for making an important point in the discussion about digitalising copyright law, namely increasing insecurity or uncertainty of a lot of consumers about whether they're breaking copyright. I think this is an important starting point. If you look at the whole value creation chain, linking content makers, traders, handlers, users, I think you have to emphasize that the starting point, the basis of all culture is the cultural content creators, and I think we need to be careful that with the aim of creating more legal security for consumers, we don't change the paradigm by putting the users at the centre of things. So when we reform copyright, or whatever you call it, I would say we need to look more at this relationship between the four main actors, above all the cultural creators. The starting point of culture in Europe is creators of culture. Copyright has to be able to answer the question of how the creation of content can be securely remunerated in the digital age. I think that's a basic precondition for securing cultural diversity in Europe. And part of this is also that we need to look at a new fair distribution. I think producers and traders have a part to play in the creation of culture, and we need to create a link between the creators of culture and the users of culture, which benefits above all the creators of culture. I think that's a key point of any future shape of copyright. One problem in the report is that we don't have a strict differentiation between Anglo-American copyright and the European form of copyright. This is a fundamental principle, and I think we need to be very careful linguistically so that we have good, sustainable results. These are the key points that I wanted to make in respect of the Reda report. Thank you.
Merci, Madame.
Thank you, Mrs. Rosière. Thank you, Chairman. I'd like to start by thanking Mrs. Reda for her work. And which clearly wants to strengthen the position of cultural creators, and for putting the issue on the table. Now, I do have to admit that we don't perhaps agree on so many points. We all want to see we all agree that digital development has changed the way in which we access cultural content. Given that, I would have liked to have seen a real evaluation of the way in which laws are applied today. The evaluation of the current situation is not so consistent. The report is more a catalogue of legislative proposals rather than setting out the current position, or without going as far as it could have done, in my opinion. So in Article 3, cultural creators are briefly mentioned. I think the general philosophy of the report focuses on the user. The user is a rather vague concept, I would say, and also leads to a few problems with the way in which the user is presented. There's a rather romantic view of a user who only wants to access cultural content without any other kind of interests or considerations. What we're seeing with the increased use of digital culture is that there's a huge change in the way in the value chain around digital cultural creation. The tight relationship between the producer or the artist and the user or consumer. This isn't suddenly a bilateral relationship. Now there are four people. You have the artist, the person who produces the work, the person who puts them into a relationship with the final user, then the final user. We can see the people who are mainly benefiting and getting most of the benefit generated by this are those the middlemen, the big companies in the middle who make this acceptable. And this has to be something that we all bear in mind in future work. Now, I don't want to speak too much at length, Chairman, but I would just like to set out a few proposals, or where I differ in opinion with you on some of the difficult topics that you raised, but I think your proposals don't necessarily go far enough in these areas. For example, the issue of the value chain. You talk about the contractual relationship between the author and the producer. Like all contractual relationships, this is not always totally balanced. I think that's something we could be concerned about, but the issue of the overall value chain is much more pressing and of greater concern. I think that should take up a large part of our work. Then we have the issue of how authors today or creators aren't protected against the illegal use of their work on the internet. the approach adopted by some countries to penalise the consumer is not entirely valid. However, we do want to prevent illegal use and, of course, profits that are generated by the illegal access to these works. Not a single penny goes back to the artists, and this is the question which should concern us. And finally, the issue of territoriality. That shouldn't be confused with the issue of portability. When you acquire access rights to content, well, if we think that the European law has to be total in this area, I think that would be going a bit far. The reasons to limit territorial access are not based in copyright reasons. They're based more on cultural diversity, ensuring cultural diversity for the European public. So I think we have to be quite cautious. Multi-territorial licenses exist already. If people want to have access to content via a multi-territorial license, then they can do that already. That already exists. So I would just say, to conclude, that as Mrs. Honeyball said, the idea is not to create protections, and protection is not the only way which will allow artists to continue to produce and allow people to have access to their works. Thank you, Mr. Negrescu.
Merci, Monsieur le Président. Je vais parler en roumain, ma langue. Facem referire la drepturile de autor.
In the information society, it's very important that we discuss copyright. Thank you very much for Mrs. Reda's initiative, to her. I think this is a topical issue, and as has been emphasised by my colleagues, we need to deal with the issue of copyright in connection with innovation and so on. Having been a creator and an entrepreneur in this field, as well as an MEP, I think it's impossible to strike a balance between 6 issues to do with copyright. We've got users who are also citizens and need their civil rights protected. Distributors and sellers aren't always. Then you've got consumers who need to be protected, and consumers and users aren't necessarily the same thing. Then the state needs to tax, it needs to protect, and colleagues have talked about that. The problem we face is a tax between those different elements against each other. And I think personally I'll be putting down a lot of amendments with regard to this report. I've talked about this with Mrs. Reda, and I think there is an openness for dialogue on a number of these issues. And you deal with a number of them, and I'll touch on them. Public information, what does that mean? And what does that mean in terms of the public space? There may be derivative products. How do we regulate those? And there are differences between the digital world and the real world, and how do we regulate those connections? And then what about taxation? We need to tax at European Union level, but there also needs to be the ability for the regions to exploit some of these creations. All these aspects have been brought out in the report, but I think we need to deal with how we can establish a clear, coherent picture, bringing together all those elements. I think we really need a common policy on copyright, and we need to establish some minimum rules because there are major discrepancies. We need to look at our own countries, compare it with France, Germany, Italy. There are differences which are often preventive of creators, users, distributors and consumers using products. So thank you very much.
Madame Niebler a demandé la parole.
Vielen Dank, Herr Vorsitzender. Ich möchte mich zunächst auch ganz herzlich bei der Berichterstatterin.
Thank you very much indeed. Well, I would like to start by thanking the rapporteur for this report and also giving us the possibility of having a deep debate on these issues. Now, my first comment, it's actually the object of the report. Mary Honeywell has already mentioned this. The report is on the implementation of the directive from the Council and the Parliament from the 22nd of May 2001 on the harmonisation of various aspects of copyright law, etc. Now, that's what's supposed to be covered by the report. So my expectation today was that on a report on the implementation of a directive that we would see first and foremost where has it actually been implemented? Has it been implemented in all EU member states? Are there different practices? Are there deficits, shortcomings? In other words, what should have been covered by the report isn't in there. Maybe you've done this, maybe you've conducted the analysis, but if you have, then maybe you could show us in terms of what's happened with implementation, what have the consequences been in member states. That should have been the core of the report, and there's really not an awful lot on that. My second comment, again already mentioned by various colleagues, what bothers me in this report, to be very honest about it, is that copyright is seen entirely from the point of view of the final consumer. Copyright is obviously an issue in which creative artists, authors, producers, all of them active in the production world are just mentioned by the by. It's not a balanced report as a result of this. All of these demands for further exemptions from copyright, it's all at the expense of the creative artists. We might have an impact assessment about the introduction of open standards as exemptions. What about all of these questions really that's been proposed or what's proposed in the report, I think waters down the creative position of our artists in Europe. We don't only want American films and concerns to be supported in Europe. We want to ensure that our creative spirits are strengthened in Europe, and so we need to really stress the aspect of their work, looking at how we can strengthen copyright or in the digital world as well, and it can't only be looked at from the point of view of the final consumer. So I think that that's something that we have to look at beyond our committee as well, those from the Culture Committee as well, and really strengthen this, because it's not possible to leave this report on this subject in this state. My final point, various colleagues have already correctly mentioned this, and that is that we have to look at the digital world and look at the creation of value and welfare. And the world has been turned on its head, it's changed completely. There are gatekeepers in the digital world who, with the help of the exploitation of the creative production from other people, they have been able to generate massive wealth. That's something we need to discuss. Is it correct? Where can we address it? So that's a debate that needs to be looked at. The whole wealth production chain needs to be addressed as well. And I don't have time to go into this in detail, but I think that in the framework of this draft report on the implementing directive, that, it's not maybe the right place, but I would like to submit various amendments, and I look forward to further debating this issue here in the committee once all of the amendments are available. Thank you very much indeed. Thank you for this debate, Chairman. Basically, we are all playing with shadows here. We are discussing like in the Black Theatre in Prague, and we are hiding the values, I think, which would justify our steps and what actually underpins the whole of this debate. Do we believe in democratizing access to culture? That's the question. We're talking about access to culture.
we want, I think, to ensure that as many people as possible can enjoy the fruits of technology, information, which can provide greater access to cultural goods. I don't think anyone would deny that. But the question is, how can we ensure that we democratize and make universal access to culture in the face of the traditional elitist approach? I think that where culture has been the privilege of an elite, the most powerful groups in society, and any intellectual worthy of the name wants, obviously, their work to be known by the greatest number of people possible. And rightly so, I would say. That's what our authors want, and it's what the public in general want as well. So the author and the consumer, the person who is going to have the cultural and intellectual pleasure generated by this creation, basically it's that relationship which gives rise to various factors which will produce a profit. And that's the second problem, I would say, related to these rights in Europe and throughout the world. In other words, that legislation which is drafted to protect workers actually tie their hands. They make slaves of them, and means that basically their creative freedom is stifled. They are involved in a production chain, and they play second fiddle to the companies who mediate between them and the consumer. And that's the basic situation in the current day in Europe and throughout the world. Exploitation of the producers. It's 80-90% of the economic value of this creation goes through the go-betweens, the intermediaries, who line the pockets, their own pockets, and those of their shareholders at the expense of the authors. We have to adopt a very clear position on this. We are at the start of a new age, the dawn of a new age, and, well, you know, as a result of my own idiosyncrasies, I want culture to be open to all swathes of the population. It should be universal. And if we want at the same time to protect the author, we can't accept that 60 years after the death of the author, their works cannot circulate freely. Well, until 60 years afterwards, it's not possible to publish for publishing houses at a price which will allow everyone to have access to it. Books continue to be an exclusive right for years. And so what it boils down to for me is, do we want to protect intellectual rights but democratize the situation, or are we on favor, or whose side are we on, the producer or the consumer of these goods?
Entschuldigung.
Well, thank you. Well, striking this balance between the user and the artist and the intermediaries, well, I think you've just said everything there. I don't need to repeat it once again. But with cultural diversity, territoriality does play a role. So I would ask you maybe to think again whether the role of this principle of territoriality doesn't or won't give rise to a limitation of cultural diversity. Shouldn't we have some kind of proportional measure for cultural diversity? Wouldn't that be a better route to follow? Secondly, the way I see this, the differences between points 11 and 13, which talks about the exemptions and limitations, which would need to be obligatory, but also there's kind of an open door being formulated at the same time. And I don't think we can marry these two. In point 6, it's on the question of the public sector there, and also I think that if we were going to do this, then the so-called public sector is something which needs to be more clearly defined. We can't leave it the way it is right now. It's on the use and reuse there. And then the duration of copyright protection. Well, I think we need to look at what the directive currently says. 60 years, I think we should retain that. On the audio-visual question, and whether this should be included in a list of exemptions, I really don't know that would help us really. If posting of audiovisual elements is in a context which the copyright holder doesn't want, well, is that an acceptable situation? And finally, I think we will need to guarantee in the future that misuse of the so-called panorama freedom has to be avoided, particularly if we're talking about commercial use.
Merci beaucoup.
Thank you very much indeed, Mrs. Boutonnet. Thank you, Chairman. Well, I have a question of Mrs. Reda. What guarantee would you offer to the to countries of which have a legal tradition which is different to that of the Anglo-Saxon countries? Well, that was a very brief comment. Thank you very much indeed. Mrs. Comodini has the floor.
Thank you, Chair, and thank you, Mrs. Reda, for coming up with this report, since I truly believe that it was time to consider whether this directive has in fact been able to work within technological developments, and also to analyse whether the directive has been restrictive or prohibitive of such technological growth or access to these services. However, I think the report has fallen into a trap, and that is the trap of taking a polarised view of this outcome. I think the best solution, the best way forward, is to really find the best balance between an efficient copyright protection that provides for a proper remuneration for creators and the objective of the public interest for access to cultural goods and knowledge. Yes, we do need to enable users to access services, but at the same time we need to generate sufficient benefits to promote Europe's cultural content and to generate more content. The fact that digital development facilitates accessing cultural content does not mean that cultural content is there to be taken. We must recognise that Europe's content is vast and has exponential growth, and so we need to protect this against its uncontrolled access for use on a commercial scale. I believe that the report should clearly distinguish, for example, between access to content for personal educational use and for commercial use, as well as consider issues of geo-blocking and internet platforms. But I do question whether it is the role of this report, purportedly one, to analyse the implementation of the directive, to come out with solutions, rather than be a report that sets the framework within which those solutions are found. The report pushes for solutions to be determined through legislation, but at the same time there could be solutions which the industry itself has already come up with. I think the current directive seems to have enabled some content holders sufficient flexibility to find solutions, solutions which are market-driven and address the actual causes of difficulties identified. For example, end users at times perceive copyright as an obstacle to access information, but this may not necessarily be the case, and at times it is the technology itself that is the obstacle, such as text and data mining, which is not merely the finding of readily available information, but it is also the putting together, the bringing together and feeding of information in specific readable formats into technological equipment. Possibly the way forward for this report definitely is to have amendments in order to bring in the balance between rights holders and end users in it. The balance needs to be retained, as the chain through which content is created includes several stakeholders and not merely the creator on one end and the end user on the other. Insofar as the single European copyright title, I think this may actually harm SMEs, especially those SMEs which we will continue to burden with more costs and bureaucracy, in a way that it will make it more difficult for them to produce cultural content in a Europe with cultural diversity. There are proposals in the report which may also vary from similar proposals made in other directives, such as the Directive on Public Sector Information or that on collective management or that on the term of copyright protection. And I think these really have to be addressed. I have a question. What are public domain works? The report proposes that these are not subject to copyright protection and so can be used and reused without technical or contractual barriers. But is the term public domain works defined adequately? The report also makes proposals on issues which seem to have been adjudicated upon by the ECJ and at times moves in the opposite direction. We need to make a decision here whether we want to keep the same position established by the European Court of Justice or whether we want to move away from that. I have another question. What is permanently located in public places? And what purpose of use are we going to allow when you have access to content which is permanently located in public places? Are we going to distinguish between personal use and commercial use? And how are we going to define the limits and the perimeters of this? The report also calls for the need to enable automated analytical techniques for text and data mining for all purposes, provided that the permission to read the work has been acquired. It seems that automated analytical techniques are licensed for use for research and education already, but the difficulty is not with getting permission to read the content, but with having the content prepared for you in a readable format for that automated analytical technique. I also, as well as Mrs. Hannibal, have my reservations on the broad exception for research and education, because the report seems to suggest a very broad exception, which we can hardly define what informal education is. I also have my reservations on the transparency proposed in private copying levies, especially, and I will close on this, especially when not all member states have as yet taken this on board. Thank you.
Merci beaucoup, Madame.
Thank you. Well, I, if I may, would like to take the floor as shadow, not as chairman. If you object, then maybe I can quickly go and sit there. Hope somebody might bring some coffee, but there are no objections, no? Then allow me to speak to the rapporteur and to you, colleagues. I'd like to start by saying, Madam Rapporteur, that I think that it's heroic. This is very perilous work, I would say, to have drafted a report on a proposal which first and foremost aimed at assessing the impact of the directive. As various of my colleagues have already said, I would say that I imagine that this is just a provisional opinion which you're going to further work on. Certain people also get quite hot under the collar about this, and quite rightly, because it's politically very important. It's economically very important as well, and that's been stressed on various occasions. Huge amounts of euros every year for cultural activities. It's, well, obviously quite a lot of money. I said that you're heroic, because if I was in ill faith, I would see in your generosity towards the users the shadow of the suppliers, as if they'd slipped into your thinking, but you hadn't seen them. But I'm not a person of bad faith, so I'm not going to accuse you of that. And then one final point. I've heard a lot of people saying that this practice that consists of defending, well, that's not what we're really talking about. We're talking about actually putting all this in perspective. The creators and the authors, basically, it's outdated. It's not interesting. But I have a very straightforward question for you, Madam Rapporteur. Copyright is one of the freedoms which were invented, well, long after freedom itself, which, as you probably know, goes right back to the ancient Greeks. The freedom of defending copyright, expressing oneself and being paid because someone has written, has used their thoughts and music, created pictures. Is that outdated, that freedom, when I have to see that in this room, not one single person, not one, doesn't think or thinks that freedom, which is at least 20 centuries old, has aged, that it's outdated, obsolete, that we should just push it out? So let's sort all of this out. The freedom to create is crucial to our citizens' thinking. It's a huge privilege for nations on the continent here in Europe who have much more wealthy from that point of view than many other continents, particularly the one which the TTIP has been negotiated. And that means that we have to protect and harmonize, but not destroy all of this. Well, actually, that's my background. I've been involved in all aspects of this profession over many years. I've also played copyrights as an entrepreneur. Most people who enjoy copyright are poor. There's only a minority who are wealthy. So I do understand that people might be concerned about the wealth of suppliers, people who go and seek out authors' works, who actually trade them. In other words, all suppliers don't pay for them. If they were to pay for them, and if they were to pay the right price for them, and if they paid their taxes where the consumers are, then I think we could probably be an awful lot more generous. But we haven't met any of those three conditions. So I would like to draw your attention to the major risks that there are in certain aspects of your report. I'm not going to list them because in actual fact they've already been mentioned by my colleagues. And finally, one last point. I was delighted to read in your report that you stood up for authors. Well, my happiness was punctured when I saw your proposal on the social networks. My grandson, well, he's 17, 18, is definitely an author, but I wouldn't compare him with Victor Hugo or Goethe. My neighbour, who's involved in music and has bought a guitar, is probably an interesting musician, but I'm not particularly interested in hearing anything more than what I hear through the wall. And let me just say, let's not destroy the major cultural value of the countries of Europe in the name of blind harmonization. I think that we have to improve the situation. You're quite right to ask the questions that you've raised. But it's like with health. You know, how do you recognize a good doctor? If he, it's because if he manages to cure his patients. And I think we should take the same approach in the cultural sphere as well and be careful about what we're saying. Thank you. Now, Mrs. Reda, you have the floor now if you want to conclude on everything which has been said. But not for too long, please, because we have other issues to deal with. Thank you.
Try to focus on some of the points that have been raised repeatedly in the debate or the specific questions that have been raised. First of all, on the question of the scope of the report. Indeed, some things like the enforcement of copyright I have deliberately kept out of this report, keeping in mind that there is a second report being drafted at the same time, specifically about the Commission's plans for copyright enforcement. And I think it's very important to distinguish what are really areas that are raised within the InfoSoc directive and how have they played out in the technological development. And regarding the question of what problems have specifically arisen from the implementation, I was indeed faced with the problem that on the one hand I have to keep the report to 6,000 characters, at least in the draft, and so I have to always make the decision whether I go into detail on the analysis or on the recommendations. And the way I've structured the report is that in a lot of times I have put more detail about the evaluation of the implementation into the explanatory statement to really show how I come to these recommendations and to stay closely to the objectives of the InfoSoc directive, which are the harmonization of copyright in the information age. So all the recommendations that I make are asking themselves the question, has this objective of harmonization really been achieved by setting mandatory certain rights holders' rights, but making non-mandatory the exceptions and limitations to copyright. And regarding the question of what has happened with the implementation, the main finding is really that in the Internet age, where people are exchanging culture across borders, the vast majority of people is not able to distinguish anymore between what is allowed and what is not allowed. That when a person goes on holiday to Paris, for example, and they take a picture of the Eiffel Tower and put it on their website, this is considered a copyright infringement at night, but not during the day. This is something that is not understandable to the average person, and it is important to make sure that we have simple, understandable copyright rules so that they can be enforced and so that authors can really benefit from them. And there, because people are exchanging culture over the Internet, having 28 more or less independent systems without any common exceptions and limitations is really causing problems. Regarding the specific question of common versus continental law and how the continental law traditions are respected in this report, I would argue that I'm actually strengthening the continental tradition of droit d'auteur in the specific recommendations that I make, because the main issue that has been raised by authors, for example, by the European Writers' Council in the last session of the Working Group on Copyright, are the unfair contractual conditions that they are subjected to, and that they do not have the ability to protect their rights against intermediaries and rights holders, because the vast majority of rights following the common law tradition is tradable to third parties. So I recommend to make certain rights inalienable to the author and to make sure, for example, that the remuneration that is collected through statutory limitations or statutory licenses that are paid for the use of an exception, like, for example, the private copying levies, that this money goes directly to the authors and not to the rights holders. I think if you really want to strengthen the position of authors, you have to see that currently the number of works being produced and being put to market in Europe is going up, but the average money or income received by an author is going down. So a big problem is existing not so much in the ability of rights holders to produce no works and bring them to the market, but in the ability of authors to make a fair living. And therefore I would like to invite all the colleagues who are concerned about authors' position to support my amendments for specific protections of the contractual positions of authors when they are negotiating with rights holders or when they are negotiating with intermediaries. Regarding the question of the definition of public domain works, I will be very happy to add the definition to the point, which is simply works whose copyright has expired. So if we have currently a copyright term of 70 years after the death of the author, every work where the author has died more than 70 years ago is a work in the public domain. And the reason why this needs to be protected is because currently we have a huge drive towards digitizing our cultural heritage in libraries, in archives, and so on. And quite often, when these works are digitized, the institutions are claiming, I will try to keep it short, that the digital version of a work that is already in the public domain is once again under copyright. This should not be the case. If something has entered the public domain, it should stay in the public domain, whether or not it has been digitized. So, and also to the question of freedom of panorama and its potential abuses. We have a lot of countries that already have implemented the exception for freedom of panorama, including commercial uses, simply following the line of argument that there is such a thing as a public sphere, and this sphere is open to anybody to do whatever they like with it. If it's not possible to use pictures of public buildings commercially, that means that every documentary filmmaker or any filmmaker who is filming in a public space has to get a license of every single building that is shown somewhere in the background. We already have a lot of member states that see that this is not possible and therefore have implemented the exception for freedom of panorama. And the criterion of being permanently in public places simply means that we are talking about buildings and we are talking about permanent sculptures that cannot be removed. So if you put a public artwork and exhibit it on the front of a building, this is not permanently in a public place. This is not what we are talking about. We're just talking about buildings and sculptures that are permanently in the public and that everybody should have a right to photograph or to film and use in derivative works. So if we don't have these mandatory exceptions, basically we're making it impossible for any works that are built, for example, by filming in a public place to really be distributed across Europe, and thereby we are actually harming the access to cultural diversity. I would like to caution against the notion that by having territoriality and by geo-blocking the access to work, we are aiding cultural diversity. I don't think that keeping people from having access to works from other countries is the right approach to protecting cultural diversity. We have to keep in mind that we have huge migrant communities within Europe that are moving from one member state to another, and if they want to maintain their cultural identity, if they want to remain in contact with the culture of their home nation, they have to be able to access such services that they want to pay for and that they want to access through the internet. Geo-blocking and the territoriality of copyright is currently making this impossible. I absolutely think that it is possible for the business models of the film industry, for example, to adapt to this new situation, and I think it has to adapt to this new situation. And there are many possibilities for this that would also be possible if the recommendations from my report are implemented, for example, by licensing different language versions of the same film to different audiences, because we still have a situation where large numbers of Europeans prefer to view films in their native language and prefer to view a dubbed version and are absolutely willing to pay for this offer if it is provided to them in a simple manner. I will keep it at that, and I will be very happy to come back to any points that I wasn't able to address now for time constraints, and remain at your disposal to draft amendments together to come to a majority on this report. Thank you very much.
Je vous remercie, Madame.
Thank you very much indeed. Well, obviously, I look forward to the time when the work of this Parliament, the words of this Parliament will not be paid, because everyone, if they have the same speaking time, there'll be no interest in it anymore. But I'm just joking. So let's move to the next item on the